Morning, everyone. Thank you for joining us for today's webinar. I'm going to give it just a few more moments to let individuals trickle into our virtual meeting space before we get our conversation today started. Perfect. I see a number of individuals have joined us, so we're going to get started. Welcome, everyone. My name is Alonso Garcia, pronouns he, him, and él. I will be guiding us through our conversation today, along with our featured panelist, Ann Block. Today's conversation is centered around common immigration hazards and traps, and Ann will guide us through what those are in our conversation today. But before we get started, I want to share just a few housekeeping items that I hope will make this presentation a little bit easier to follow. I do want to share with all of you that today's conversation is being recorded, and you'll get a link to our YouTube video once it's available. You'll also receive all of the resources along with today's presentation that Ann has put together for us. You'll share Ann and my contact information towards the end of today's presentation. And if throughout today's conversation, if you have any questions, please utilize the Q&A or chat feature to ask any questions. We will be leaving time at the end to answer all of your questions. We also have closed captioning available. If you want to enable that, you can either hover at the bottom of your screen or at the top and click that CC icon, and you'll be able to have today's conversation live captioned for you. With that, I will turn it over to our amazing speaker today, Ann Block, and she'll guide us through our conversation today. Thanks, Ann.
Thank you so much, Alonso, and hello, everyone. Thank you for joining us today. So today, hopefully, will be a very interesting discussion and presentation on a lot of the different hazards and traps that come up for people in applying for immigration, particularly keeping in mind students, as you all are. So what we're going to cover today, we're going to start with marijuana in immigration, and that's going to take up a big chunk of our time because it's become a really big issue since California has legalized marijuana and very confusing to many people, especially those dealing with the immigration system. Then we'll spend a little time talking about DUIs and how they impact immigration. We'll discuss marrying too soon or don't marry too soon if you're in the process of immigrating in certain categories. Registering to vote, voting, and false claims of citizenship as they impact immigrants. And then we'll close up with a little bit on social media, tats, and gangs, and end with sex and immigration, since that is a way, hopefully, putting it at the end will keep you all here. So let's start off with talking about marijuana and immigration. Unfortunately, even though many states have legalized marijuana, which is, in my opinion, a good thing, this does not affect federal laws regarding the fact that marijuana is still considered a controlled substance under federal law. It's still illegal. And because immigration is a federal law issue, that means the use, possession, and other activities with respect to marijuana are still illegal under federal law and still impact immigrants. So what I'm going to try to do today is go through all the different types of actions that can cause problems for both people that are permanent residents and people that are not yet permanent residents, but are not citizens broadly. And then we'll talk about what impacts those are going to have on immigrants specifically, and then what you can do to avoid these problems and things, different actions and things to do to help keep your immigration case alive and not denied and moving forward. So the different actions that can cause problems for green card holders specifically, because sometimes it's different with respect to what impact, how things impact green card holders and how they impact everyone else that's not a citizen. So if a green card holder or permanent resident, LPR, as we call them for short, travels over 6 months outside the US, that can cause a problem if there's been some activity or conviction relating to marijuana. Any travel outside the US, and then as they're coming back, making a formal admission, and we're going to talk about what that means later, of a federal criminal marijuana offense to immigration when they return, that can also be a problem for LPRs. Working in the legalized cannabis industry. I bet many of you never thought about that because, hey, you know, it's legal here in California. A lot of people work in the cannabis industry, but it's a huge problem for people that are not yet US citizens. State or federal convictions are always still problems for green card holders as well. And that could include, you know, there's still some things related to marijuana that are illegal in California, like planting too many marijuana plants, cultivating too much of a greater category than is allowed under the law. Driving under the influence of marijuana is also, you could be convicted for that. And anything else related to marijuana that's still illegal in the state. Or if you are convicted of something under federal law. So then what can cause problems for those that aren't yet green card holders? A lot of the same things, plus a little bit more, okay? So if you have DACA, you're undocumented, you have a student visa or some other temporary type of visa, these actions involving marijuana are something to avoid. Any travel outside the US and then disclosure of marijuana activity when you try to return. So Customs and Border Protection officials, or CBP as we call them, that are stationed at the land borders, the sea borders, and the airports have gotten wise to the fact that many people in California and the other states where marijuana has become legalized do in fact use it. And so they'll often casually ask somebody when they come back, it's like, oh, you live in California, huh? So everyone's using marijuana here, I suppose you do too. And if you say yes, that's a disclosure of marijuana activity, and that can get you turned around and sent back out of the US if you're not yet a permanent resident. And it can cause problems if you are a permanent resident too, but not as serious. So disclosure of marijuana within the last year when you're applying for permanent residency or a temporary visa. In other words, you disclose to an immigration official or to a medical doctor in an immigration medical exam that you've actually used marijuana within the last year. And we'll talk about why that is in a little bit. Again, another thing that affects non-LPRs, just like LPRs, is any formal admission to a criminal offense, even if you don't have a conviction. And we'll discuss what that means. Working in the legalized cannabis industry and convictions, again, either state or federal, are problematic. And so here are the immigration consequences related to these. There's 5 major bad immigration consequences related to marijuana. First, you can be labeled a quote unquote drug abuser, okay, when you're trying to get your green card or some sort of visa to enter the US, or you're trying to come back to the US, okay, after you've legally. And that's usually due to disclosing use of marijuana within the last year, okay, just within the last year, or lab tests at the immigration, done at the immigration medical exam, which indicate that you have used them because marijuana shows, or THC shows up in your blood or your hair. Usually it's just blood tests that they do. Now, this is a temporary bar, okay? It basically lasts for 1 year. There's no waiver, though, to get around that 1 year bar, and it's a 1 year bar from last use. The next major bad immigration consequence is the complete denial of a green card or a visa or reentry, or actually being deported for a conviction related to marijuana, or a formal admission to a marijuana-related crime. These are permanent bars. There is one exception and one waiver for one-time simple possession, 30 grams or less of marijuana, okay? Plus one possible relief from removal or deportation. Removal and deportation are basically the same thing now for some permanent residents. Another bad immigration consequence, which is even worse in some respects because it doesn't require a conviction, it doesn't require an admission, a formal admission, is denial of a permanent residency, a visa, or reentry for and also possible removal for permanent residents if they travel, is reason to believe that somebody's a drug trafficker. In other words, immigration authorities say, we have reason to believe, based on information that we've received or information that you've told us, that you're a drug trafficker. And this, believe it or not, includes people working in the legalized cannabis industry. They have been accused and denied for being drug traffickers, even though they're working in what is legal in California, or working in something related to a job. For example, someone that was installing cameras, security cameras at a cannabis warehouse or shop. I'm not sure what it was. They were required by California law to have security cameras, and he was maintaining them and applied to get a green card and was denied because of his employment. In addition, any of these things can lead to mandatory detention by ICE. Usually being labeled as a drug abuser does not, but having a conviction or reason to believe can very well end up with that. And that means ICE jail, basically, which in some instances is, in some places, can be almost as bad or worse than our regular jails and prisons. So that's something we always want to avoid. And finally, it can lead to denial. Marijuana activity can lead to a denial of US citizenship if it's disclosed or there's an admission or a conviction. And also then the person can be referred to immigration court for removal proceedings. All that's pretty scary, right? It's really scary, but it's really important everybody realizes this. It's really unfair. ILRC is working actively to try to get marijuana consequences for immigrants removed at the federal level. But it may take the complete legalization of marijuana, which a lot of us are also working on the federal level to make that happen. So how do you avoid these really bad consequences? Okay, if you're a permanent resident, a green card holder, don't travel outside the US if you're using marijuana. Just don't, okay, if you can avoid it. Don't travel inside the US to a state where marijuana is still illegal, which is a little less than half the states or around half the states right now. So look it up and take your product with you. So you can travel, but don't take marijuana in your luggage. You know, don't end up like Brittany Griner getting detained in Russia or detained in a different US state because you have marijuana with you in your luggage. Don't violate state laws, even where marijuana is legal, but they still have limits, like we already how many plants you can have or driving under the influence. If you're a green card holder, don't plead guilty or no contest in criminal court if you get charged with something related to marijuana. Get good expert criminal immigration advice first, because many criminal defense attorneys have no clue how this is going to affect your immigration status or your future immigration status. If you've already pled guilty or no contest because you didn't get good advice, you very well may be qualified to vacate that conviction, get rid of it completely through post-conviction relief. Don't admit to the elements of a criminal offense to a government official. And we'll talk about the details of that again in a minute. Don't sell or even give away your product. And don't work in the legalized or illegal cannabis industry. Note that you can still be denied US citizenship for a lack of, quote, good moral character for even recently using marijuana and disclosing that to government officials. So if you have DACA, or you're undocumented, or you're a visa holder, you're not yet a permanent resident, I always tell my clients it's just best if you don't use marijuana or other non-prescribed drugs unless you absolutely need to for health reasons. And just know that then you're going to have to figure out, if you have a green card application pending, for example, how you're going to deal with that immigration medical exam and how you're going to do it. Now, some consulates, for example, some people have gone to adjustment interviews, some people have gone to consular interviews with marijuana cards, marijuana prescribed to them for health reasons, and they've come back fine. That's not been the case with people that have to go through Ciudad Juarez in Mexico. So any Mexican that has to leave the country to go through consular processing there really needs to be super cautious and avoid using marijuana for a year before going there. Somebody made it through Belize with their marijuana card and came back a permanent resident without a problem. So a lot of times it depends. But best if you can avoid using it when you're in the process of getting legal immigration status. Especially don't travel outside the US if you're using marijuana. And again, don't travel inside the US to a state where it's still illegal. And again, don't violate state laws relating to marijuana. Pretty much the same for DACA undocumented visa holders. Don't plead guilty or no contest in criminal court. And if you already did, look into getting a vacatur. ILRC has helped push through a lot of different laws in the California legislature. They've been very immigrant friendly in recent years in getting post-conviction relief, getting rid of convictions when people didn't understand the bad immigration consequences related to them. So there's a lot of possibilities there. Again, don't admit to the elements of a criminal defense, don't sell or give away your product, don't work in the legalized cannabis industry, and very, very important, don't use marijuana within 1 year of your plan to apply for a green card. A lot of these are repetitive, as you might have noticed, but hopefully that helps keep them in your mind and make them useful to you. So here's some examples. Here's an example of someone who likely will be denied as a quote unquote drug abuser. Example of Manuel. Manuel's been living in the US undocumented and wants to get his green card through his US citizen spouse, Paloma. Manuel obtained a provisional unlawful presence waiver prior to leaving the US, which many people have to do if they've been living here without status for over 180 days. And so he got that waiver, attended his consular interview for his permanent residency. At his immigration medical exam that he had that was required prior to the interview, he was asked about drug use by the doctor there. And he explained he used marijuana a couple times 8 months ago after the couple's baby died. Nevertheless, of the mitigating circumstances, the horrific circumstances of his marijuana use, he's still denied for being a drug abuser. And he has to take random drug tests and attend drug classes. Once 1 year has passed with no use, and that might be just another 4 months because he's only admitted using it 8 months ago, he can then claim he is in what's called sustained remission from drug use and no longer be considered a drug abuser. But there's a big but. He may still likely have to now apply for a regular unlawful presence waiver, which he had already gotten, if Ciudad Juarez, if the consulate actually denies him completely rather than just puts his case on hold because of that unlawful presence that he had after the age of 18 of at least 180 days. Those particular waivers are now backlogged about 2 years, and that might mean Manuel is stuck not just another 4 months in Mexico, but another 2 years waiting for a new waiver approval. Okay. I've got somebody right now that wasn't my client initially, but came to me after they got stuck in Mexico. It wasn't marijuana, but it was another type of conviction that his former attorney didn't get vacated before he left. And he'd gotten that unlawful presence waiver, but now he needs a new one. We got the conviction vacated, but he's got to wait now for a waiver. We tried to get it expedited, and so far, no luck with that. So who might not be denied as a drug abuser? Here's a better example. Rafael was better prepared for his medical exam and consular interview. He and his attorney delayed filing all his documents online for consular processing with the National Visa Center until almost 1 year had passed since his last marijuana use. So then later at his medical exam, he was able to explain truthfully he had not used marijuana within the last year. He also did not admit to the elements of a criminal offense to either the doctor or the consular officer, who did not actually try to elicit an admission. They don't often do that, actually. Rafael was approved and came back to the US within a week or two of his interview with his permanent residency. Here's another example of a disclosure, not an admission, but a disclosure of THC use and when an LPR is traveling. It's an example of Joanna. Joanna is a permanent resident, left the US to go visit her mother in Chile, and while she was there, her mother became very ill. So she stayed in Chile for over 6 months. Remember, 6 months is important for permanent residents She stayed there for 7 months. And while she was there, she consumed gummies to cope with stress, as she'd also done in California. When she finally returned, the immigration officer at the airport asked her, well, you live in California, right? And I suppose you sometimes use legal marijuana products. And she said yes. She was placed in what we call deferred inspection, sent to a medical exam to determine whether she's a drug abuser and whether she should be placed in removal proceedings. And that would not have happened if Joanna, as a permanent resident, had returned to the US in less than 180 days, even briefly, and then gone back to Chile, unless she made a formal admission to all the elements of a criminal offense to the immigration officer, which again, rarely happens. She would also, however, need to take care not to abandon her permanent residency by maintaining all her contacts here in the United States and keeping furniture here, keeping bank accounts here, keeping all sorts of different contacts here, and getting a leave from a job, for example. One more example. Again, a disclosure, but not a formal admission. It's a Lee example. Lee's returning to the US with a student visa, and the immigration officer at the airport again casually asked if Lee uses marijuana occasionally, since it's legal in California, and Lee says yes. Lee is sent to secondary inspection. Remember, Lee is not a permanent resident. Lee is coming in with a student visa. And eventually Lee is denied re-entry to the US with a student visa and shipped back to China. It's unlikely Lee will get a new temporary visa, but may eventually, nevertheless, still be able to become a permanent resident if there's a way for Lee to do that through family or employment or other means, as long as Lee didn't make a formal admission to a marijuana-related crime. So now we're going to talk about admissions. I keep mentioning them, but I haven't really told you how this happens. So formal admission to a drug offense, including marijuana, is just as bad as having an actual conviction in court. And that happens when you admit to immigration officials, either when you're applying for a green card or other visa, or returning from the US after travel, that you have used or possessed or done something with marijuana or another drug, and your admission sufficiently matches the elements of a federal marijuana offense. Plus, there's a big plus, officials have complied with the admission validity requirements. And that's where, and one of the reasons why they don't usually do it. And even if they try to do it, they usually screw up, and that helps. They have to provide an adequate definition, including all the essential elements of the offense, and explain it in terms that are understandable. So here's the things that the Board of Immigration Appeals, which where immigration removal cases go on appeal after an immigration judge decides them, and what they say goes nationally in terms of immigration rules, unless Congress changes the rules. So for an admission to a drug offense to be valid for immigration, that immigration official or officer has to provide a full explanation of their purpose of their questioning. And that comes after the person has declared that they committed an offense. They say, oh yeah, you know, I had marijuana in my backpack, or I used marijuana, or I've been under the influence of it before. I worked in the legalized cannabis industry. The officer must provide the applicant the text of the specific law from the jurisdiction where the offense was committed. Okay, in other words, they have to show you the law. They have to take out a book, or they have to print it out and show it to you and go through it with you. And they have to provide an explanation of the offense and all the parts of it that you'd have to plead, that you'd have to agree with to make you guilty of the offense in basic, ordinary language. And then you have to voluntarily admit to having committed each element of that offense while they have you under oath. And they can't promise you anything. They can't coerce you to anything. They can't say, oh, just, you know, go ahead and do this and everything will be fine, because it won't be. And it must be under oath. So if they start doing this with you, you just got to stop it. You just have to say, no, I'm not, you know, I don't agree to this. Sorry. And that's it. And then you haven't made an admission. And if you don't have a conviction, then you're much better off. They could still get you for reason to believe you're a drug trafficker if you admit, if you disclose that you've worked in the cannabis industry. So don't do that. Okay, just say, I can't talk about it. I'm not telling you to lie, just don't answer those types of questions and get an attorney to help you at that point. So here's an example. Julie went alone to her green card interview and admitted to using marijuana. The consular officer who interviewed her decided to try to get an admission to a federal criminal marijuana offense. He said he was going to show her the law that she violated, the federal criminal code section on marijuana, and explain it to her. He told her she didn't have to answer his questions. What will happen? So if she voluntarily complies and he does all the things he needs to do for a valid admission, she will likely be permanently denied permanent residency. Okay, that's bad. If she refuses to comply, she might be found ineligible as a drug abuser. Remember, we talked about that, but that's not a permanent denial. It's for 1 year, at least if you stop using drugs, and they might send you to random drug testing and classes and that sort of thing, and you have to show you haven't used it for 1 year, but it's not permanent. At consulates, there's no discretion to just deny permanently in this type of a case if there's no conviction and no formal admission. But here in the US, when you're applying in the United States, some people are eligible to apply for adjustment to permanent resident here. Julie might still be denied for a refusal to answer under discretion. But in such a case, then she could go ahead and ask the immigration judge to review her case. And she could also, discretion is a balancing act. If Julie has lots of good equities she can give the immigration officer, that should balance off this fact that she's used marijuana in the past year. At least it would with many immigration adjudicators. If Julie's coerced by the consular officer, or lied to, or made promises, or the consular officer doesn't provide her with all the elements of the criminal offense, then it's not a valid admission. Okay, then she doesn't have that problem that's the same as a conviction. So hopefully this has given you some defenses if this sort of thing comes up. But again, it's rare. I've been practicing immigration law for a long time, and it's rare that sort of thing comes up. More often people are denied for being drug abusers, so to speak. And that normally happens mainly at the consulate in Ciudad Juarez and not within the United States at adjustment interviews, although it has occasionally happened here. So the moral of the story of the Julie story there, keep talking to an immigration or consular official after they show you the elements of a criminal offense. They're trying to entrap you into legally making an admission. Just don't. If you unfortunately get scared, talk anyway, it's still possible they screwed up, they messed up, and they didn't elicit a valid admission. So you need to get help as soon as possible. And again, if this is happening, you need to get help before continuing to talk to them, if you think of it, and hopefully you will. So it may seem really bad in the moment when you have this officer that is making a decision on your permanent residency and you're refusing to talk to them. But if they deny you after you've refused to talk to them, you could get that denial overturned potentially successfully. But if you make a valid admission, that can be much, much more difficult, if not impossible. So don't talk. All right, we're done with marijuana for now, but we'll take questions at the end on that. Let's talk about DUIs and immigration, another thing that comes up a lot. For people of DACA, it's bad. It's considered a significant misdemeanor, and it will lead to DACA denial or revocation. For everyone else, it might lead to a denial of an application that's discretionary, okay? Like adjustment to permanent resident inside the US, an application for a waiver that you need, relief from removal applications before an immigration judge. But again, for discretionary reasons, it doesn't make you otherwise ineligible to immigrate, and that requires a balancing of the positive about you and the negative. For people that are here on student visas, tourist visas, worker visas, it will likely cause a denial or revocation of that visa. Okay, and that's bad. Again, that's temporary though, and also might result in a denial by the consulates for permanent residency, especially in Ciudad Juarez, again, under the health grounds of ineligibility, or what we call inadmissibility, for being a threat to self or others. And like being a drug abuser, that's for 1 year. for 1 year until you can prove sustained remission from alcohol, quote unquote, abuse. And alcohol abuse, especially in Ciudad Juarez, if it comes up, can be found even for disclosure of having drunk at your medical exam to that doctor. The doctor is an arm of the consulate, not a doctor like your doctor at home. Just disclosing drinking 3 to 4 beers on a weekend day has caused someone to be denied as an alcohol abuser. We think that's incorrect legally, but that's what's been happening at the consulate in Ciudad Juarez in the medical exams there. And it's very difficult to litigate and to work on to overturn consular decisions, because a lot of courts have found them outside the jurisdiction of US courts because they're not in the US. So how do we avoid that or reduce the negative impact of arrest? So of course, if you can avoid a DUI conviction, do so. You might be able to plead or ask your public defender or your private criminal defense attorney if you can plead to wet reckless. You can still maintain your DACA. DACA is still discretionary and they can still deny you for anything, but if you plead to wet reckless, there's no requirement that they deny you because it's not a significant misdemeanor. It's not a DUI. Even better is straight reckless. And DAs will a lot of times go for that in many types of immigration cases, particularly DACA. And then submit a lot to immigration along with your DACA renewal, a lot of what I call the 3 R's. Take responsibility for whatever happened, express a lot of remorse, and show rehabilitation. Just inundate them with lots of great specific recommendation letters and how great a person you are. Documentation that you're in school, documentation that you have a job, do volunteer work, whatever you do. Or you can fight the charges. Sometimes DUIs definitely are defensible. So, plead without discussing it, without talking to your criminal defense attorney about your immigration status, and asking them to then contact an immigration attorney to discuss your status. It's really, they have the requirement as your attorney that they figure out the immigration consequences. They can't just send you to someone else to do it, but make sure they do. And it's not a bad idea to check it out yourself as well. So you get convicted of a DUI anyway, even though you've tried an alternative plea, you tried potentially fighting it. For DACA, what can help is asking for early termination of probation. Usually DUI probation is for 3 years. And then if you can get probation terminated halfway through, which is not uncommon, at 1.5 years, and get an expungement, which is kind of a rehabilitative post-conviction relief. It's not as good as completely vacating a conviction, but it actually works for DACA. Then you can build your positive equities, show rehabilitation, do all these things like are listed here. And you get the expungement, you might be able to then renew your DACA. But timing is important. Usually you can't get probation terminated earlier than 1.5 years. Might be possible. And DACA is usually for 2 years, right? So it is for 2 years. So you want to get that expungement and that probation finished before you have to renew your DACA again. And even a DUI arrest can lead to revocation of temporary visas, like students or tourist or working visas, and denials of a green card at the consulate, at least at Ciudad Juarez. Note that this is important to know. If you're here on a student visa, working visa, tourist visa, just because the Department of State revokes your visa, that visa in your passport, does not mean that your status here in the US is revoked. You still have your student status, you still have your tourist status or working status. You just cannot travel outside the US and return. The visa gives you the right to enter the US. It doesn't have anything to do with your status once you're here. That is, the length of your status is initially determined at the airport or at the land border by CBP. If you're a student, you get duration of status, D/S. And as long as your school keeps renewing it, extending it, you're okay, as long as you don't travel, okay? So how do you avoid a diagnosis of alcohol abuse disorder apart from a conviction? How do you avoid being considered an alcohol abuser, especially by Ciudad Juarez? Well, knowledge helps, right? The doctors are supposed to follow, both the doctors for medical exams here in the US and at the consulates, the Diagnostic and Statistical Manual, edition 5 of the American Psychological Association. And that says the presence of at least 2 symptoms that they list indicates an alcohol use disorder, or an AUD. A mild one is the presence of 2 to 3 symptoms, and that is enough. If you answer yes to the questions that indicate 2 or 3 symptoms, that's enough to get you denied as an alcohol abuser. And expungements don't help. So what are those symptoms that they're looking for? Let's look at that. So the DSM-5 questions for alcohol abuse diagnosis include 11 presently. Doctors, of course, can ask similar questions. They don't have to ask specifically these, but this is what they're the types of questions they might be asking you to determine whether you're an alcohol abuser. So something you can think about in advance. Have you had times when you ended up drinking more or longer than you intended? Certainly when I was in college, I did. And even more recently, I have drank more or longer than I intended when I'm out with friends somewhere, okay? More than once have you tried to cut down or stop drinking or couldn't? Have you spent a lot of time drinking or being sick or getting over after effects? Haven't gotten sick since I was in college, but I did then. Wanted to drink so badly you couldn't think of anything else. Found that drinking or being sick from drinking often interfered with taking care of home, family, job, school. Continued to drink even though it was causing trouble. Given up or cut back on activities that were important because of drinking. More than once gotten into situations while or after drinking that increased your chances of getting hurt, such as driving, swimming, walking in a dangerous area, using machinery, having unsafe sex. Have you continued to drink even after made you depressed, anxious, or had a memory blackout? And had to drink more than you once did to get the effect, or found that when the effects of alcohol were wearing off, you had withdrawal symptoms. So you can go back and look at these. You'll get copies of all these slides. Here's an example of how this works in real life. Jorge has a DUI arrest from 6 years ago. He didn't get convicted. He just had an arrest, okay? And either the charges were dropped or maybe he pled to straight reckless. At his consular medical exam at Ciudad Juarez, he explains that since he has never drunk alcohol, since then, he's never drunk alcohol and then drove a vehicle. But he says he regularly drinks 3 to 4 beers most weekends. Jorge is found to be an alcohol abuser by the physician and denied his green card application by the consulate. He's required to show 1 year of sustained remission, attend AA in Mexico, or go to alcohol abuse classes and follow other instructions by the doctor and consulate. Another example, Beatrice has a DUI conviction from 3 years ago. A conviction and itself, right? And more recent past than Jorge. She goes to her medical exam, incredibly explains to the doctor how she attended AA and has completely stopped drinking at all since her DUI. She's granted her permanent residency visa. It's a big difference, right? One more example, Winston has a DUI arrest from 3.5 years ago as a freshman in college, and he pled guilty to wet reckless. He has a consular interview in Jamaica and is asked some of the questions from that DSM-5 list. Winston says, yes, there were times in the last year he drank more than he intended during parties. And there was probably a couple times where he had unsafe sex while drunk. 2 of those questions were yes, right? So he's found to have a mild alcohol abuse disorder, denied permanent residency. Again, he'll have to show 1 year of sustained remission and won't be able to return to the US in the meantime, unless he has DACA and was able to obtain advanced parole travel permission prior to his interview and use that to go to his interview. Then he might, in fact, be able to come back. That's hard to get the timing of advanced parole right for DACA people, though, in my experience. So enough with DUIs and marijuana and convictions and all that. Now we're going to talk about getting married too soon. A little happier conversation, but just, to let you know that some immigration categories don't allow you to get married before becoming a permanent resident, and you will automatically lose any pending case for a green card if you marry too soon. For example, permanent residents can only petition to immigrate their unmarried children. They can also immigrate their spouses. But for children, the children have to be unmarried and they have to remain unmarried until they become permanent residents. So if you have that situation, hold off. Children immigrating through a petition filed for their parent as the parent's derivative also lose their ability to immigrate through that petition if they marry. Many people have been getting U visas as derivative children of their parents' U visa application or their siblings' U visa application. And they will lose the ability to get that U visa if they get married before they obtain U visa status, and possibly, potentially, if they marry before becoming permanent residents, which they can apply for 3 years after becoming, getting their U visa status. In addition, children of asylees who were under 21 when their parent applied for asylum, their age gets frozen then. And so even if they turn 30 and their parents finally get asylum, they will get asylum too as a derivative because their age got frozen when their parent filed, but they'll lose that ability to automatically obtain derivative asylum if they get married before their parent is granted asylum, and then they also are granted asylum. So best to just live together till the immigration case resolves. There's certain cases where actually getting married can help your spouse get green cards too, but you really have to make sure you're in that situation and get good immigration advice. Having children with a partner is no negative for immigration if you're unmarried, and usually is actually a positive because you have additional great equities. You have children born here. Again, consult with an expert immigration attorney or nonprofit before you get married. And church weddings count as being legally married in the United States. Some countries, you have to only go through a civil procedure in order for that marriage to be legal, but here, church weddings count as well. Here's one example. T's grandmother, US citizen grandmother, petitioned for T when T was only 10 years old. T's mother's minor unmarried children were all considered eligible to immigrate as derivatives of that petition. But it took many years for that petition to have a current priority date. And before that happened, T got married when she was 19 years old. As a result, T could no longer immigrate through the petition filed for her grandmother, by her grandmother, excuse me, for T's mother. We're coming up on election season again, so it's also just good to remind you all that if you're not yet a US citizen, don't register to vote and don't vote. And in addition, don't make false claims of US citizenship, which is part of actually registering to vote, which people often don't realize because a volunteer is checking the boxes for them and just having them sign the registration form. So only US citizens can register to vote and actually vote in state and federal elections and most other elections as well. But some cities and school districts do allow non-US citizens to vote, but you have to be certain that that's law. It's really, really important because this can mess you up forever. Most voter registration volunteers have no clue about immigration consequences, and often they just assume that everybody they're talking to is a US citizen. So be extremely cautious. They will often, say, oh, let's register you to vote, sign here, and then they fill out everything else for you, including checking the box that you're a US citizen. So it's usually best just not to vote until you are a US citizen. The bad immigration consequences for doing any of these things are denial of a green card or visa, which is permanent, very, very narrow exception that almost nobody qualifies for, and deportation, including for permanent residents. Relief is only possible if they're here in the US long enough before they've registered to vote or voted or made a false claim. So here's an example. This is a real example. One of my real clients, names are changed. Some of the other facts are changed. Guadalupe became an LPR a few years ago at age 18. When she was in college, she was approached by a volunteer registering students to vote. She didn't know, and she wasn't told she wasn't yet eligible to register to vote. Thought I wrote her that in a letter, but maybe I forgot, or maybe she just forgot or didn't read it. So she agreed and signed the form, but does not actually remember checking the US citizen box. So the volunteer probably did that with her. She later learned from her attorney that what she did made her deportable. She had not yet voted, which was good, and following her attorney's advice, quickly withdrew her registration. Her attorney advised her to wait till she had 7 years since her lawful admission to the U.S. before applying for citizenship, in case she was found deportable. And that way she'd have a chance to apply for a type of pardon or relief from removal. So how to avoid this? Don't sign petitions, cards, forms without completely reading them. Don't register to vote, no matter who says it's okay. Your teacher, your coworker, boss, friend, just don't do it if you're not yet a U.S. citizen. And don't tell anyone you are a U.S. citizen when you're not, especially in writing or to a government official, like for school financial aid, for a loan, for a mortgage, on the I-9 form for a job. Saying that you are a U.S. citizen is like the kiss of death for immigration purposes if it happened after September 30th, 96. There's a few things you can still, ways you can still immigrate, like through a U victim of crime visa, T, asylum, but not through family immigration. So don't sign an I-9 form for your employer claiming you are a U.S. citizen. Some people, I always tell my clients, you know, usually you get a whole bunch of forms to sign when you're getting a new job, and you sign them all without reading them. So if you signed a whole bunch of things without reading them, you don't know you signed an I-9, I think you can say, you know, as far as you are know, you never signed an I-9 form. And usually that will be sufficient for your immigration case. Saying you are a permanent resident when you are not will sometimes cause immigration problems. Like if you said that to an immigration official or an I-9 form, that's what's considered visa fraud. But that's much less problematic for most people than an actual claim of U.S. citizenship. But again, it's always best to avoid discussing your status if you're undocumented. So real briefly, just social media, tats, and gangs, something to be aware of is that USCIS and consulates will look at your social media to see if they can find ways to deny you residency or a visa. The consulates actually require that you list all your social media platforms and names or handles that you use. And a federal court just this month upheld their right to do that for people that are outside the US requesting visas, including green cards, to come back. So really important to keep your social media accounts private if you can, and delete any problem posts and pictures when you're in the process of applying for a green card or a visa. And these are the sorts of things I always tell clients to delete and to avoid is party pics showing marijuana or other drug use. And that includes those that you're tagged on by your friends or that they post on your account. Underage party pics that look like a lot of underage kids with drugs or alcohol. Posting gang-related information, signs, graffiti, hand signals, wearing of colors, gang-type colors together with other people, and photos of guns or other weapons. So sometimes tats, a lot of, you know, everybody says tats these days, but a lot of times tats are misinterpreted. And for a long time, government officials, and even many of them now, associate a lot of tats that aren't gang-related as still possibly gang-related or actually gang-related. So if you have tats that, you know, might be related to a particular gang, but even though you didn't get them for that purpose, best to change those tats before you go to a medical exam to apply for a green card, because they will often have you strip and look at all your tats. Former gang members can still obtain permanent residency, but it's difficult. And they have a burden to prove that they're no longer affiliated. Consulates say, well, we'd like to see that you've been a snitch in order to prove it, but there are other ways to prove that as well. And those that already have green cards that are former gang members have a stronger basis to defend themselves because the government has a burden of proving they are deportable. People for a while thought removing tats would work for consular processing, but medical doctors there got wise to it and started using black lights to look for removed tattoos. So that's why it's always better to change your tat to something neutral. Last topic, sex and immigration. Who knew that could be a problem, right? Usually it's not. Usually it's not. And the immigration problems are caused by convictions, okay? Just by convictions or admissions, like we talked about, admissions to either drug crimes or crimes involving moral turpitude, which sex crimes fall under crimes involving moral turpitude, are problematic. So sex with an under 18-year-old partner, and the younger the partner, the greater the age difference, The worse the conviction if you actually are accused of doing statutory rape, for example. That's consensual sex with an underage partner. Sex without consent at any age is considered rape, including with a drunk or a high partner who's unable to consent. Sexual or lewd contact with a minor, even consensual, and that's under 18. And that includes much more than just vaginal or anal intercourse. Sexual battery, like groping a breast, grabbing somebody's butt, kissing them even, if it's without their consent, or possession, use, or distribution of child pornography. And again, note that sex in these contexts does not just include vaginal or anal intercourse. Oral sex and other activities as well can lead to convictions if it's with a minor or non-consensual. So why do folks get charged criminally for some of these acts, especially if it's consensual sex with an underage partner? Well, first of all, US culture is very conflicted about what age use sex is not abusive. Under 18-year-old maybe got pregnant or indicated sexual behavior, and a mandated reporter to the police, like a teacher, a counselor, or medical professional, gets involved and lets the police know. The parent of someone who's under 18 finds out, is upset, and calls the police. Seen that happen. Maybe the parent was okay with the relationship and then becomes not okay and calls the police. Someone's jealous and calls the police, or calls the parent who calls the police. I've seen that happen as well too in under 18-year-old situations. A partner gets upset and calls the police. So can I be charged with sex with an underage partner if I am under 18 as well? What do you think? Unfortunately, it's yes. So bad immigration consequences can include denials of green cards, visas, reentry, deportation. There are exceptions with respect to CIMTs, crimes involving moral turpitudes, and a waiver is possible for some of these convictions, but not all. Admissions are a problem, like we talked about, making a formal admission. Rape, for example, is an aggravated felony. Sexual abuse of a minor is an aggravated felony, and that's kind of the worst of the worst for permanent residents, and that includes some misdemeanors, not just felonies. Again, mandatory detention by ICE can happen. DACA will be denied for any felony or significant misdemeanor, which includes sexual abuse, and you can be denied citizenship. So what to avoid? Avoid sex with under 18-year-olds. Some of them, including those that lie about their age, find older partners. Avoid sex when you or your partner are drunk or high. Avoid initiating unwanted sexual or intimate contact, like kisses, pats on breasts, but always ask if it's okay first. Don't do sexting or accept or send porn-related photos of genitals, breasts, etc. to anyone under 18. Absolutely don't do that. I've seen major problems come up with that. Do use contraceptives, avoid pregnancies, consider the feeling, unless you're planning with your partner to get pregnant, of course. Consider the feelings and concerns of the parents of your partner if it's an underage partner. So let's go to questions. Looks like we have a few here. The Q&A. To clarify, it says, you stated if you have past use and disclose, you will be barred for 1 year for drug abusers, and the reason to believe does not come into play. Okay, so reason to believe will only come into play if you indicate something that makes them think you're a drug trafficker, like you sold marijuana, or even, said you give it away. That probably isn't trafficking, but I still wouldn't say that. Or worked in the legalized cannabis industry, because the cannabis industry is selling and distributing drugs, right? Marijuana, at least according to the federal government, it is. But with respect to drug abuse, that just has to do with use and disclosing the use, or being tested and determining that you've used. And yes, it'll be 1 year from last use. Okay, 1 year from last use. And again, it seems to vary. Particularly among the consulates, in terms of what is considered abuse or not. Because just use, if you look at those DSM-5 questions, there's no, just use is not enough. It has to be use plus something else, plus at least of the 2 of these things. But In Ciudad Juarez, it seems like if you just admit to use within the last year, they're going to deny you. Okay, not the case for every other consulate. It says, how often are people sent to Ciudad Juarez? If they are applying for a green card and they are not eligible to adjust their status here in the U.S., which is most people nowadays, especially. There are still a good number of people that are eligible to adjust here in the U.S., especially if they came into the U.S. And were admitted and inspected, either with a visa. Sometimes children are brought across the border in the back of cars. CBP officer looks in, waves them in, or sometimes they just wave the whole car in without asking them questions. And that's an admission and inspection enough to be allowed for some people that are immigrating through certain family members to adjust status in the U.S., like through a spouse, or if they're a parent and they have a 21-year-old U.S. citizen child, they're considered immediate relatives, or their parent is a U.S. citizen and they're unmarried and under 21. What type of imagery should be avoided in tattoos? That's an excellent question. When I have somebody with tattoos, I usually try to Google different law enforcement sites and see what they think currently different gangs use symbols are in tattoos. I mean, if you have a tattoo that says MS-13, pretty obvious, right? But there's certain sorts of animals and other sorts of images, sometimes numbers, because there's a number of gangs that use different numbers or Roman numerals to signify gang membership. Those are often problematic, but I can't tell you, as I'm not an expert in tattoos, but I know when I've had clients with tattoos, I ask them to send me photos, and then I start looking up on law enforcement tattoo sites what currently is considered a problem. How can signing a petition affect DACA? I'm not sure what kind of petition you're talking about. If you're talking about, you're talking about when I said don't sign petitions without reading them. Generally, it's just a good idea to read everything that you're signing, because my clients that have had problems like registering to vote when they didn't really know they were registering to vote, or claiming something on a form that they didn't really intend to claim, it's just always a good idea to read everything that you're signing. Most petitions with respect to changing policies or politics, no, that's not going to affect anyone with DACA. Okay, that's just not. So that's a very good question, and thank you for that. As an undocumented person, if I applied to college and said I was a temporary or permanent resident, so I wouldn't have to pay out-of-state fees, will that cause any future legal consequences? What if I said I was a U.S. citizen? If you said you were a U.S. citizen, that's very problematic. It's a false claim of citizenship, and it makes you ineligible for most methods of immigrating, other than T visas, U visas with a waiver, asylum. Saying that you're a temporary resident or a permanent resident, that isn't necessarily about immigration status. That's usually about residency within the state as opposed to immigration residency, and you're not making that particular claim to an immigration official. For a false claim of citizenship, making it to any type of government official for any purpose, type of official purpose, can be a problem. But for saying you're a permanent resident, for example, that can make you be found to have committed visa fraud, which is different, kind of overlaps with a false claim. But there are waivers for some people, like if you have a parent or spouse who's a permanent resident or U.S. citizen, it could be waivable. But what you're describing to me might not even be that. It makes a difference who it was to and whether it was material to an immigration benefit. And out-of-state tuition, in-state tuition is not an immigration benefit. So that's probably not going to be an issue. So we're right at 1 o'clock, Alonso, and if you have additional questions, check out our website at ILRC. We have a lot of different community resources there and information there about all the things I was talking about. You can also follow us on Instagram. And then I think there's one more slide here that Alonso, whoops, there we go. You can also get a consultation. I'll let Alonso talk to you about that.
Yeah, thanks, Anne, for today's wonderful presentation. I learned so much, and some great questions were asked. if you want to keep the conversation going, or if you just want to talk further with an attorney on, anything that's happened to you in the past, or if you have questions about, family-based petitions or how to navigate it, all three systems of higher education do offer free consultations. So if you visit findyourally.com for California Community College students, you'll be able to schedule a consultation there. Findyourally.com/CSU and or UC will bring you to the legal services for the Cal States and the UC system. All consultations are free of charge. So, please take advantage of that. And then they will also do a thorough and comprehensive screening to make sure that you're eligible for any other forms of relief. And lastly, we currently are offering support for DACA renewals and paying that $595 filing fee, as well as if you're eligible to apply for naturalization. Naturalization applications are currently being covered through the end of this calendar year. So take advantage of those. If you have any questions, feel free to reach out to Anne or myself. All of our contact information will also be available in my follow-up email. Today's conversation was recorded, so I will share today's presentation along with Anne's wonderful PowerPoint and some additional resources that the ILRC has put together for us. So thank you all for your participation. I hope you found this helpful. I know I did, and we will share everything in the upcoming days. Thank you all.
Bye, everyone.